Good afternoon, everyone. I'm Gillian Sadler, Chair of the Ulster Society, and you're all very welcome to the latest in our series of webinars with our legal partner, A&L Goodbody. We've had consistently strong interest and positive feedback from our members throughout this series, so thanks once again to A&L Goodbody for taking the time to share their insights and expertise with us across a range of topical legal issues. As always, we will be recording today's webinar, and for anyone who wants to catch up on previous sessions in the series, you can do so on our website, charteredaccountants.ie/Ulster. Today, we have James Flanagan with us to talk about what can happen when contracts go wrong. James is going to focus on the issues that he is regularly asked to advise on in these circumstances, including managing disputes, how to prepare for termination, and what constitutes loss. And I know James is keen to share some practical hints and tips, along with some examples to really bring the discussion to life. James is a partner in A&L Goodbody's litigation team with a focus on construction and infrastructure matters. He has over a decade of experience in dealing with both contentious and non-contentious construction, contractual, and procurement matters across both the public and private sectors. James regularly advises clients on contract disputes and matters ranging from arbitration and High Court matters to adjudication and expert determination. We will have some time for questions later in the session, so please put your questions for James into the Q&A box at the bottom of your screens. The Q&A is open now, so feel free to type them in at any stage during the presentation. Just a reminder to keep your questions general in nature. James can't provide answer any specific legal queries during the webinar, but if you want to reach out to him with more detail afterwards, you are welcome to do so. So we'll get started. James, you're very welcome, and over to you. Thank you.
Thanks very much, Gillian, for that introduction. And I'm very happy to be doing this webinar today, and appreciate the interest that has been shown in this presentation. So I'll just share my screen here. Okay. So as Gillian said, I'm a partner in A&L Goodbody in the litigation team, and advise on a number of construction infrastructure related matters, and also basically do a broad variance of work between the contentious and non-contentious matters. So today's agenda, typically when I want to discuss the likes of remedies under contract, I think I'm always asked to sort of do a brief overview of contract law, and I'm going to try and do a bit of a quick refresher on that, because clients always tell me that they appreciate it, and I think it also puts the more specific items that I'm discussing into a better context. So there'll be a brief overview of contract law, which will really focus on sort of the basics, and then I'll really go into sort of the performance obligations under the contracts, how then that's sort of dealt with in terms of breach of those obligations, so breach of contracts, how that's sort of dealt with. Then typically what we're always asked to sort of opine on is on loss, and how that's supposed to be dealt with in terms of recovery. Then on the various types of dispute resolution forum and some of the key differences. And this sort of speaks to my own sort of practical experience of clients maybe not having the full understanding of that. But then just on like termination of contract, the risk associated with it, my own experience with it, and then just sort of like general practical tips for guys to sort of take and use in your experience. I mean, I'm very conscious that a lot of you will be going to talks and seminars with lawyers, and what I really try not to do is sort of overload the technical legal issues, and really try and provide some colour and sort of flavour to the issues that I deal with myself generally, and give more practical guidance that you guys can use in a real life scenario on a day-to-day basis. So typically, look, as most of my work is all contractually based, with maybe some regulatory components, I just want to do a brief run through of the essential components of a contract. And it's interesting that I often find that even very sophisticated clients can sometimes seem to overlook this, or think that none of these will apply, and that they're actually in a contract. So very simply, there has to be offer and acceptance. One party effectively offers to provide or do something to another party, and they effectively accept it on those terms. There has to typically always be consideration, either the exchange of money or goods or other services, in order for that to be bound. And there has to be a real intention here to create legal relations. Those four sort of pillars are very much cast in stone at this stage. And it's interesting that sometimes whenever parties are more focused on the minutiae of the details, sometimes these very simple things can be forgotten about. They're almost taken for granted. So sometimes I think it's a good example to sort of give an indication of whenever you're doing offer and acceptance and how that sometimes might apply with parties not really being sure as to whose contract terms apply and whose order of priority takes precedence in terms of whether there's perhaps an exchange of contracts. And a classic example is what I have here, is whereby you effectively have a number of parties, and party A submits a purchase order to the other side, party B, and party B will respond with its conditions of sale. And then party A resubmits its purchase order. And if we assume that there's been offer acceptance, intention to create legal relations and things like that, that's all been satisfied. Both parties believe they've satisfied those conditions. And then in this scenario, B goes ahead and supplies the goods. This typically comes up sometimes where you're dealing with parties that are in a rush to get either a purchase order issued or a transaction sort of dealt with quickly due to various other matters. So in this typical scenario, what would actually happen is that A's contractual terms and conditions will more than likely take priority, and there is a legal precedent for this. So it's something that an industry in particularly, it's very much prudent to be aware of what's the latest in terms of terms and conditions. And we often see this with purchase orders, where purchase orders effectively may refer to underlying terms and conditions that are maybe not actually attached to the purchase order, but maybe actually attached to the website, publicly available elsewhere. And at that stage, the party who accepts the purchase order maybe has just missed that and doesn't accept it. And typically this sort of matter will only really come to a head and be realised by, let's say in a situation party B, if there's some ambiguity as to how the contract is being performed, particularly when it comes to payment, because some crafty businesses will maybe issue a purchase order with terms and conditions found elsewhere. Party B effectively accept it because they've accepted the purchase order. And party B maybe believes that their conditions of sales and their payment conditions applies when actually it'll be A's payment terms applies. And if A's payment terms are a bit more onerous in terms of the time allowed for payment or perhaps interest on late payment, this can provide some difficulties. So particularly when you're dealing with purchase orders, always try and work out what the terms and conditions say, where they can be found, and do they align. And sometimes if you have a situation whereby you have a situation like this, contracts typically can say that, where there is a purchase order or an underlying terms and conditions with the counterparty, that our terms and conditions will take priority if there's any ambiguity. That's another sort of practical tip that we see applied in this type of situation. And that's the relevant case law. So, briefly what I want to go through here is this is your typical structure of a contract. So you've got your typical commencement when it starts, which I'll come to, the parties, the recital, basically giving a background, your definitions, which can be very important if there ever is any ambiguity, your performance obligations, your indemnities, limitations and exclusions, typical boilerplate type wording, like your governing law, things like that, execution, signature, and schedules. So for today's talk and these purposes, I'm really going to try and focus on like performance obligations, indemnities, limitations, and exclusions, effectively the operative part of the contract. That's not to say that the rest aren't important and can't cause problems further down the line, but this is sometimes, where the real focus on a contract and where the real perhaps risk resides in a contract. One thing that I'm commonly asked for and find that it's typically a problem is that sometimes parties are always unclear as to when a contract begins and actually when do these services or the provision of goods becomes conditional under the contract. And there's usually a number of reasons for this. One thing that is always worth remembering, and I think this goes for businesses and professional services, individuals like lawyers and accountants, etc., is that lawyers are often asked to advise upon matters where there actually isn't an executed formal contract. The parties might believe there is. The parties might believe that a contract has been signed by both parties and properly executed and dated, when in fact it hasn't been. Maybe one party has signed the contract or another party has signed a different version of the contract, and therefore there isn't a properly executed document. And that can pose some risks in terms of particularly limitation. So if you have a contract where you want to maybe have a limitation period of 12 years, like a deed, there's a lot of formal requirements. In order to execute a deed, typically it has to be executed by two directors of a company, or a director of a company in the presence of a witness. And we see this constantly not being done, and that can pose real issues down the line, because if you have a deed, you typically have a 12-year limitation period to bring a claim under a deed. But if the deed isn't executed properly, then real questions arise as to whether or not you have that limitation period of 12 years. The same happens with a contract, although executing a contract is a lot less formal than a deed. The same issue applies. We often find that this is more so a governance issue in peace. And typically the issue arises because the parties are so quick to enter into a contract once they think they've got the material terms agreed, that they don't actually remember the basics, that it needs to be properly signed and executed and dated. And one of the issues that we often see now is that from a governance perspective, a lot of parties don't ever actually check who the registered directors are of a company. So parties might have contract documents provided to them, believing they're properly signed, but you'd actually need to go on Companies House and check whether or not those people are authorised directors of the company at the time they've executed the contract, so that they have the proper authority to bind the parties. So that's a real governance issue that we often see, particularly on the execution date. In terms of the operation of the contract, a number of contracts can effectively be dated one day, but effectively don't start in real terms until a date in the future. And sometimes this is effectively a conditional date, whereby certain things have to be provided to the other side in order for the contract to commence. So you actually could be in contract, but nothing's really going to happen unless you satisfy these condition precedents that are typically known. And that might be, a form of insurance cover, maybe performance bond, warranties, collateral warranties, parent company guarantees. If those things aren't provided, the services can't start under the contract. And again, it's interesting how often there can be misunderstanding as to when the contract actually starts and when it's effective from. And that, again, there's often a wrinkle in terms of its limitation period. We go back to the point I was previously making about a deed having a 12-year limitation period. Sometimes there's a concern as to, well, when does the 12-year start? Is it from the beginning of the contract? Is it from the services starting under the contract, if all the conditions have been satisfied? Or is it from the date of the breach under the contract? Depending on the way the contract has been typically worded, there may be exclusions in that effect. So it's always something relatively straightforward and seeming somewhat basic, but something that we constantly see not being done properly. So it's always just worth noting. The performance obligations really define, what the contract is all about and what it's intended to do. So it's always very important to sort of identify what the obligations are on a seller or a buyer in terms of what they're delivering, what they're buying, what's the standards that have to be applied for. And in that regard, you might have various sort of conditions applied upon a party. For instance, they might have to use their best endeavours to provide certain goods or services. In that instance, that's a high threshold for a party to satisfy. The use of best endeavours is probably the highest threshold you can have in a contract. And if you have a best endeavours threshold on your delivery of goods or services, the typical phrase rolled out is that you'd have to perform that to the last penny of your fortune in order to ensure that that's being done correctly. Whereas if you maybe have all reasonable endeavours or reasonable endeavours instead of best endeavours, that's a less onerous obligation. So those sort of things are always really worth sort of trying to identify very quickly in a contract as to the level and standard that you're being asked to adhere to. It's not something that is standard for every contract. That can very much change and be bespoke. One thing that is particularly worth noting is that I often am asked to advise on quite large contracts that literally in terms of their size, they can contain a number of schedules containing very bespoke and at times some very complicated technical information. And whilst I have to be very careful in terms of the technical documents and the substance of the technical information, what often can be the case is that there's standards and conditions within those schedules. You can have a major energy project may have a standard sort of terms and conditions with about 20 to 25 schedules attached to it. And in some of those schedules, there may be standards that actually contradict what's in the terms and conditions, basically the front end of that contract. And there's been a number of cases whereby this has caused real difficulty, particularly in terms of technical specification, the standard and quality. There's a very famous wind farm case whereby it was undetermined whether or not there was a fitness for purpose obligation on a developer, which meant that they had to build this wind farm and had to be completely fit for purpose, or whether or not there was a 20-year warranty on the usefulness and the purpose of the wind farm. And that went all the way to the Supreme Court, and it basically fell upon some text that was in the schedules of the construction contract rather than in the front end. So always sort of advising people in industry, if you're entering into contracts, sometimes the real devil in the detail is in the schedules, and sometimes there can be a real sort of more casual attitude to it because there's a reliance on the technical expertise, but it can have a real impact on the legal analysis interpretation. And in that regard, it's always worth having like an interpretation clause or a an order of priority clause, I should say. An order of priority clause will effectively demonstrate that if there is an ambiguity or contradiction between, let's say, a term in the terms and conditions versus a phrase or a sentence that's in the schedules, that one, either the terms and conditions or the schedule will take priority over the other. That sometimes is a very simple way of dealing with it, but it sometimes will not be, the complete resolution of the issue. So always take particular notice if there is a schedule or number of schedules appended to your contract, particularly when it comes to technical standards and conditions. So typically under contracts, we have performance obligations are really categorized typically in two terms, conditions and warranties, with a third category being intermediate terms. And the intermediate terms could either be a condition or a warranty, and sometimes that requires some resolution, and that can prove quite difficult. But for conditions and warranties, it's very important for parties to be aware of that classification at the outset, because whether a clause is a condition or whether it's a warranty can have differences in terms of what happens if there's a breach of that condition and what remedies are available. So if there's basically a breach of a condition, it may be possible to terminate the contract and claim the damages, not just for the breach of the condition, but also for the ultimate termination. Or if there's a breach of the condition, you can effectively seek that condition be rectified by a cure period, and then claim the damages that you've incurred as a result of that condition not being adhered to. Typically for warranties, your most immediate remedy is a claim for damages, and your claim for damages would be to put the party seeking the relief to be put in the position had the warranty not been breached. And then with an intermediate term, again, that will sort of depend on what the court's classification of that breach would be, but it would likely fall within a condition or a warranty, assuming that it wouldn't be considered an indemnity. But it's important to keep those two classifications in your mind and be aware of the differences, particularly when you're looking at warranties and warranty breaches, because the relief you'll typically only get is a claim for damages. Indemnities are often a source of major negotiation and discussion when we're dealing with counterparties. Effectively, it's because the purpose of the indemnity is to really make sure that the other side is kept whole and basically pay them any specific loss that has occurred in the event in the scenario where a specific event has occurred. And what the onus is with indemnities typically is that it's not usually the law that will say when an indemnity applies or the relief that has to be applied, it's the contract. So, there very much is an onus, and the courts are now more aligned to say that, look, contracting parties are quite sophisticated. They have lawyers involved in these types of scenarios, and therefore they'll not seek to interfere and say indemnity does or does not apply. They'll very much say that if a contract says something, and whether an indemnity is particularly onerous on one side, the courts are more likely to find that the parties have agreed to this bargain, and it may just be a bad bargain, and the indemnity applies. And indemnities can be drafted in a number of ways, either to effectively pay out the damages that you've suffered or the loss that you've suffered, or it could be drafted in such a way as to hold the other party harmless, where that loss perhaps goes beyond typically what you would expect in that scenario. So indemnities are, very early in my career, you effectively were told, you warrant what you know and you try to indemnify what you don't know. The difficulty with that is that if you maybe don't know some of the risks in a contract, that your indemnities can be wide-reaching. So it's always very, very important to know that typically when contracts go wrong is when there's maybe some ambiguity under an indemnity, or the risk under the indemnity perhaps wasn't fully appreciated at the time it was given and can be more broad-reaching than first envisaged. So effectively, any unknown risks and to simplify a claim. So typically, you know, if an indemnity is payable, it's effectively a demand will be called upon under the indemnity the other party has to type and cover off. What we're typically seeing now is a lot of indemnities being asked to cover off data breaches and IPR claims. This has very much been facilitated by GDPR. And GDPR is quite onerous on parties now. It's obviously been brought in for the right reasons, but the remedies available and the relief available to a party that has suffered a GDPR breach is quite extensive and can go into the tens of millions in terms of monetary relief. So those indemnity claims are typically, you know, indemnity provisions are now typically drafted to cover off the exposure of a breach under the new GDPR regime. So typical care has to be provided in terms of that. And then in terms of the indemnity, it can maybe apply to different types of data, different types of breach, and different types of intellectual property rights. So that's just typically where we see it coming up. However, it can be used typically as well under likes of SPAs and things like that for more sort of like corporate reasons or issues. Look, under a breach of contract, it's a phrase that's typically bandied about, but the extent of the breach is not always equal. So it very much depends on the commercial background of the document and the transaction, and the extent that it maybe is a real risk to the parties contracting and their relationship going forward. There's some certain things in which parties cannot contract out of. So, you know, we have like the Unfair Contract Terms Act, which includes some provisions that parties will never be able to contract out of. Similarly, you can have you cannot contract out of any risk or liability for death or personal injury, and typically negligence isn't permissible to be contract out of. Although some contracts may include a liability clause that will say that the total liability for us under this contract, including any claim of negligence, will be a set figure. And also most contracts, particularly if you're dealing with the sale or exchange of goods, will try and contract out of the Sales of Goods Act, because that includes, sort of similar to my point about the schedules to a major contract, particular quality and specification standards that parties don't want to be held liable to. Those are typically things that are held in boilerplate. They'll be kept in a number of contracts, but it's always just worth noting. Whenever we're asked to look at a breach of contract, there's a number of key factors we have to consider, because even though a party has maybe, you know, in the counterparty's eyes committed a very obvious breach, and therefore expect to be made whole or paid a specific amount to remedy that breach, it's usually not that simple. So typically when we're looking at a breach of contract, we have to consider causation, and causation is a real live issue, because causation effectively works where if there is a breach of contract, but then something that may have occurred after that breach that has effectively increased the loss being suffered by the other party, that might not be the other party's fault. There's the line of causation, which is effectively like a very clear thread between the breach of the contract and the loss being suffered. Mitigation, and this is something that I'm always sort of asked to see advised upon. So basically, even if there is a breach, that is not a sufficient right to effectively claim major loss and seek to recover a great deal of monies afterwards. If a party is claiming a breach of contract, they have an imposed duty to mitigate their loss. So it means that a party cannot use a breach of contract as like a commercial opportunity to effectively increase the size of the claim. And if that does happen, or if a court is looking at this, they will assess it and review it and effectively reduce such a claim to a position where a claimant should have been acting reasonably and not try to further their loss. And then there's contributory negligence. Perhaps if there is a loss suffered due by the party seeking that relief. So if maybe the other side committed a breach of contract, but they did so because we were unable to provide them the information or the specification that we were contractually obliged to do, and therefore we are in part liable for part of the breach. You know, a party cannot benefit from its own breach of contract. So these are always things that have to be considered whenever contracts go wrong, and is there a breach of contract, and how this can be really dealt with in the round. But one of the key things that we have to consider whenever there is a breach of contract is ultimately what the loss might be. Obviously, this depends on the nature of the contract and the consideration involved, but we're typically asked to advise on what loss is, and particularly the classifications of direct and indirect or consequential loss. And this all really goes back to a very famous case, Halley versus Baxendale, which goes back to like the 1850s and deals with the supply of equipment. And basically the equipment wasn't delivered on time to a party to be repaired, and the person relying on that equipment suffered loss and claimed for their loss of profit as a result of the delay. I'll not go into more details than that, but effectively that established a legal principle about the remoteness of damage and whether damage was foreseeable or not. So whenever we're dealing with major contracts, one of the real items that we have to constantly give consideration to, and is usually the subject of negotiation, is what constitutes direct loss, as in what are the losses that will naturally flow from the breach of contract, because that is typically established to be normally recoverable. So if there is a typical, breach of contract for delay, you might have liquidated damages. That will remedy it. Or if there's been a breach in the standard and terms or the quality of a component, your loss might be the differential between you not having the quality of that component at the time versus when you get it. Those things are typically, not much of a dispute. The real dispute arises where we come to things that are like indirect or consequential loss. And these are typically things that you would naturally assume would be a relevant consideration, but based on the circumstances of the contracting parties, and particularly the terms of the contracting parties, these may be heads of loss that actually are recoverable and should be drafted in such a way so as to identify that the heads of indirect or consequential loss will be recoverable and the other party will be liable for. And that typically depends on the specific nature of that contract, but it's always the case that I think they should be addressed and identified clearly from the outset, because there can always be an argument as to whether or not a loss suffered is direct or indirect. And to try and sort of bring some resolution to that ambiguity is typically whether or not the loss was foreseeable or not. If the loss is typically foreseeable or the other party has known about it, that usually enhances the possibility of recoverability. If the loss is either not direct or indirect, it might not be recoverable and be effectively so remote that you have no right to recovery. So that might be in a situation whereby there's been a breach of contract and you might not have, and a company might have been tendering for an opportunity. It might have been one of 10 companies going for another commercial opportunity. And because of this contract, they're effectively saying, well, we would have won that other contract if it wasn't for the breach of contract under this regime. That might be too remote, because there's no way to guarantee that even if the breach of contract hadn't have occurred, that you would have won that contract in that tendering exercise without other commercial opportunity. And that's sometimes where there can be a real dispute about, is whether there was a loss of profit or a loss of opportunity. So because it can be quite broad reaching in terms of your risk under a contract and what you might be liable for, there's so many heads of losses that you could have that typically contracts are basically drafted to exclude a number of heads of losses. And where we often get into difficulty is where there is a loss of profit, loss of use, loss of data, or loss of occupancy. And usually in this scenario, we try and identify not just the head of loss, but we actually try and give some color to it in order to mitigate the risk. Because while we might have loss of profit, we'll consider to be an indirect loss, but it's recoverable under the contract. But there then comes a point in a dispute where, well, what do we mean by loss of profit? How do we actually understand what profit is? Yes, there might be a legal definition of it. There's obviously an accountancy definition of it, but there can be various definitions of what profit actually is, and particularly under the contract that the dispute relates to. So whenever we're trying to advise a client, particularly when there might be a risk, such as a loss of profit or a loss of use, a way to really sort of mitigate risk is to give specific consideration to the definition of what that actually means in the terms of the contract. Usually what we'd have in a contract is like an limitation of liability clause, or basically a waiver that the other party is not liable for loss of profit, loss of use. We could either call that an indirect or consequential loss, or we could effectively set out what that actually means in real terms. The more clarification that can be applied to and those definitions and those heads of losses, the more likely that there's going to be a major dispute about it. Now, this can sometimes, overcomplicate maybe sometimes simple transactions, but whenever, no one really cares what a contract says unless the contract goes wrong. And what we typically find is that there may be a major risk, particularly at this moment now, what we're seeing with data. And sometimes there could be a dispute over what the data meant in terms of the contract. Did it mean data in relation to a set of customers or organizations or institutions, or does data mean the entirety of services provided by that organization to another? So certainty and clarification when you're doing your limitations and you're excluding various risks like your losses is always a really beneficial step. But the real devil is in the detail. So if you are trying to carve out like a loss of profit risk, add some definition as to what profit actually means or what standard you're using it to. If you're referring it to a definition, like an accountancy definition or one used within industry, make sure that point's being made, so that if there ever is a dispute about it, there isn't, months being lost and costs being incurred trying to establish what we actually meant by loss of profit. In terms of my own experience, I mean, one way I was involved in a quite significant dispute, whereby there was a major performance contract that was being used that had to deal with a certain type of product. And this product had a number of different components that would vary as the year went on. And what had actually happened was that the two parties in this contract had actually entered into another contract where they effectively tried to establish the components that would be used in the other contract. However, there became real issues under the performance contract based on this product. And as there is an entire agreement clause, which effectively tries to close off any previous agreements that were held between the parties and effectively try and cordon off the contractual risk within the four corners of the contract, that the parties couldn't actually, the party who'd suffered loss due to the poor performance of their contractor couldn't actually rely on the other agreement that the same contractor had effectively used to prepare the specification of these components. So in some ways, there was a real difficulty for us trying to claim full relief and recovery of our loss against the contractor because they had effectively provided us with this specification. But because we had accepted the entire agreement clause and not proportionally carved it out to also include the contractor's performance under this scoping contract, for want of a better phrase, our actual limitation was quite limited and would have been far greater had we also been able to rely on the breaches of the contractual performance under both contracts. It was effectively a gap in the interfaces between the two contracts, and that is a major issue that we typically see, whereas an entire agreement clause is very helpful to limit off your overall exposure. Sometimes it's actually forgotten about that there's actually another contract or a scoping document or specification used under another contract that we're relying on that we need to include within the contract and effectively get a suitable undertaking or a warranty so that if there is an issue that causes us problems under this performance contract, we can rely under that previous contract. I've seen it under major construction projects whereby one contractor was seeking to rely on another contractor's work, but there was no real interface or exchange between the two contracts as regards specifications, drawings, standard of works, models, etc. And this then caused real difficulty on the second contract because that exchange or interface wasn't there. And I have no doubt that the parties involved in drafting that contract included like an entire agreement clause to effectively ensure there was no outstanding risks and to mitigate the risk of both parties. But it was forgotten about. There was a clear interface and exchange between two contracts. So that's something that also needs to be sort of remembered. That entire agreement clause is always very helpful. But if you're relying on another contract for the contract you're entering into, there needs to be an exchange or interface. Similarly, if two parties are in a contract and they want to exclude another party from relying on the performance of that contract, that's where the Contract Rights of Third Parties Act comes into, and there's basically a standard form of wording that would go into every contract which seeks to exclude third parties from the reliance and performance of that contract. Those are typically the sort of limitations and exclusions that we always see, but sometimes they can cause real difficulties the parties couldn't have foreseen at the time. In terms of contractual relations, I often sometimes think that we sometimes are asked to advise on contractual liability, particularly limits of liability. You know, parties are very keen to ensure there is a contractual overall cap on liability. So no matter what happens under the contract, our liability to the other side is 5 million or 10 million. And it's surprising how often I'm asked to advise on a scenario whereby the insurance provisions under a contract don't actually align with the overall liability under the contract. You know, whether you're, you know, in industry or any sort of profession, effectively, if you're dealing with a counterparty, they're effectively only as good as their insurance in some respects, because their insurance is designed to cover off any risk or issues that happen under the contract. Otherwise, if you don't look at it in those terms, you're maybe dealing with an uninsured entity that may not have the means to pay you for any damages that suffer under the contract. So it's always very important to always check that the total liability under a contract and the contracting parties aligns with their insurance cover. And that can be quite difficult, particularly because the insurance market at the moment is quite stretched, quite strained. But typically, you know, I've had a case whereby the parties agreed to a, you know, professional indemnity limit of 10 million, but another clause in the contract said that the contractor's total liability to the employer was for 2 million, regardless of how the claim was brought under the contract. So the employer believed they were getting cover for 10 million, but didn't appreciate that actually the contract was capped at 2 million. So sometimes there needs to be a bit of thought and consideration put to that and make sure that those parties align. So that's typically where we see issues go wrong. We also see that some parties, whenever they have an insurance cover, there's always a rush to maybe agree the size of the figure under insurance provisions, be it professional indemnity, employer's liability, public liability. But the rush to the figure, be it 5 million or 10 million, sometimes is actually not the material consideration. The real consideration whenever you're dealing with insurance is whether your insurance cover is deemed to be what they call in the aggregate. So if a contractor says our professional indemnity cover under this project is 10 million in the aggregate, their cover will be 10 million all in for either one claim or 100 claims brought under the contract. Whereas instead of using in the aggregate, you can also see alternative wording, which is 10 million cover for one event or a related series of events. In that instance, there's a 10 million pot of insurance cover for any particular breach under a contract or related series of it. That's obviously a lot more beneficial if you're the employer and you've got that sort of type of cover involved. But it's sometimes a situation whereby the parties don't appreciate that nuance. They believe that in the aggregate means the same as for one event or related series of events, and they're not the same at all. So I'd also flag that as a risk. And again, you know, your total contractual liability is really only as good as your insurance. So it's also important to make sure that your insurance clauses contain the relevant sort of limits of insurance cover that you're happy with, but that they also align with the total contractual liability under the contract. And when things go wrong, as they often do under contracts, it can be referred to a number of forms of dispute resolution. And I'm sometimes often surprised by parties, particularly clients, when they agree contracts, because I think there's always a hope and expectation rather than naivety that things under a contract will go right. And sometimes that's just not the case, even if both parties mean well and want to perform well. And under this forms of dispute resolution, you can have your court proceedings, which will be your typical high court, county court, small claims, etc. But they're public proceedings. They're known. They're published. You know, they're the ones you read about in the news. They're the ones that the judgments are available on the court website. And sometimes really sophisticated clients don't want that public exposure or even the threat of that public exposure. So some of the biggest disputes that go on between companies are never made public. They're dealt with arbitration, and arbitration is the key difference between arbitration and your court proceedings is that public exposure and that spotlight. Arbitration and court proceedings are often very different, very similar in terms of their form and their substance. You know, there will be pleadings, there will be discovery, there will be experts involved, but it's the protection of publicity that is really attractive to arbitration. But arbitration is also very expensive, and I've been involved in disputes whereby my client who entered in the contract at the time wasn't aware of the risk of arbitration and the difference with court proceedings. They assumed it was broadly the same, and it wasn't. And also then the cost and expense of doing it, and also the time demand. They didn't appreciate the full value of it. So it's always worth sort of flagging those things that we sort of maybe take for granted as lawyers, but maybe the laypersons just aren't aware of that nuance. Also, like I'm regularly involved in adjudications and expert determinations. Adjudications more related to the projects construction type sector, and it's effectively a very truncated form of dispute resolution. Usually the proceedings start and end within 28 days. It is a rough and ready form of justice, and with that comes with it a lot of risk, because you could get an adjudicator who can be very detail orientated and very much follows the law, or an adjudicator who maybe is more minded to the conduct of the parties and might be more sympathetic to more sort of emotive arguments than legal arguments. So there's always a risk with adjudication. And similarly with expert determination, I mean, again, I've been in contracts and asked to advise on matters whereby the parties had agreed to appoint an expert if there was a dispute. And the real concern is that the expert determination will be binding and you won't be able to unlock it if you're not happy with the result, and also the cost and time and expense that's awarded with it. So these are sometimes matters that I've personally encountered whereby parties weren't aware of the significance of different types of dispute resolution. They either assumed that they were all like the court proceedings, but that's not. And what I would always say is that, there's no form of dispute resolution is without risk. They're always associated with risk. You could just get an arbitration panel or a judge on a bad day who just doesn't like your legal arguments, even if they're the best legal arguments in the world. So in that regard, a lot of contracts now are trying to include like escalation procedures, whereby the senior executives or management of a company effectively meet together to resolve a dispute rather than go down the legal route. And because typically to go down the legal route to a major form of litigation will be costly and will be timely, typically a drain on management time. So it's always useful to try and have an escalation procedure involved if you can, to try and maybe bypass and see whether you can get an overall resolution to the dispute, or alternatively seek to narrow the issues that are being disputed. However, things don't go great. There always is a risk of termination, and one party terminating the other party for effectively a breach or a series of breaches. And there's always a massive risk with termination, because it can and often does go very wrong. And so there's always a risk that terminating a contract with another party can be considered unlawful. And that effectively means that termination was invalid and you're effectively held for an unlawful unlawful termination of contract, or repudiation of contract, where your actual losses and exposure for doing so could be far bigger than what the liability cap was under the contract. So whenever you're going down the termination route, it's very unlikely that you're ever going to know 100% that you're right in terminating the contract. I was involved in a matter with one of the top KCs in London, and he effectively said to me once, I was quite junior at the time, that you can never be sure when you're terminating a contract whether you're right or not. You'll never have that full comfort. You can only do your best. So really, it's a risk mitigation exercise. Terminating a contract, you try and lower the risk. I had a matter I was involved with about a year ago, whereby I had a call with a client in the morning about a completely different project. And later that evening, they blind copied me into a correspondence on a different project, which I wasn't involved in, with another side, and effectively had served notice of termination. And the rights of termination that they had applied were because the other side were a day late in paying them. And the contract had been drafted in such a way whereby they said that, look, if there was a late payment, if there was a payment that was late under the contract after a period of, I think, 90 days, they would have a right to terminate, but that right to terminate was qualified, and that our client had to effectively send a reminder letter, which then included another, I think, 30 days after the reminder letter. Our client had never sent the reminder letter, so our client had effectively just sent this letter off. They hadn't also followed the notice provisions under the contract. They hadn't called a letter a contract notice. But I read this letter and was completely bemused by it, and effectively had to phone my client very quickly that night and effectively say, this is an unlawful breach of contract that you're claiming here. You're not right in doing this, and this is a major red flag. And even then, the client wasn't fully aware of the risks when I said that. So I had to fully explain what that meant, that if the other side take this as a termination notice, they could go after you for unlawful termination. So sometimes whenever you're looking at termination, even if a party has committed a breach of contract, that's not sufficient. Usually, if you're going to terminate someone, you have to build up your case. Like, one breach usually on its own is not sufficient. There has to be usually a catalogue of evidence, and that really is dependent on your contemporaneous evidence and your documents that you have. And when you're doing that, sort of exercise, I think you typically get a sense of whether or not this termination is going to be lawful and supportive. What you also have to be very mindful of is that there typically is a cure period under a lot of contracts. So even if there is a breach, the party who's committed that breach may be allowed to rectify it and remedy it so as to nullify any right of termination you might have. As that example shows, I've often seen that where parties don't allow the cure period. They just look at it in such a way whereby they believe that they have an immediate right to terminate. And sometimes that's because the termination provisions make a very scant reference to a cure period or rectification process, which might be another part of the contract. So there isn't that immediate correlation. It requires a full understanding of the contract. And if you're going down the termination route, follow the procedure that's in the contract to do termination. Typically, if one party issues a termination notice to the other party where their relations have been cordial and amicable, and there haven't been letters either saying that they will rely on their termination provisions, or there have been breaches under the contract, that won't be sufficient. There should be always a period of time to allow a party to rectify the issues before you go straight to termination. So in terms of like practical notes, I would say it's always mindful to try and spot risks under a contract being entered into. So from my own experience, it's things like, do the technical documentation, specification and schedules and things of that nature, do they align with the terms and conditions, or are they saying something completely different? And if they are, is there specific provisions in the contract to address with like an order of precedence so that the terms and conditions could take priority over a schedule? Or if it's a major like project or EPC contract, like, are there relevant interfaces or exchanges under the contract with other counterparties to allow that there's no delay claims or ambiguity between different counterparties? Or is it a project whereby you're involved with a number of counterparties, but you have to rely upon the performance and specification prepared under other contracts? Is your contract specifically drafted in such a way so that you can rely on that performance in those other contracts? Is that specifically carved out? I mean, one thing that always carries a lot of risk is variations and changes to contracts. I mean, I have an example. I'm advising a client on a matter whereby they had entered into a contract for a specific price. The contract got suspended for reasons that had nothing to do with them for a period of, I think, a number of years. And they agreed a variation to effectively suspend the contract for a period of time. Now they want to recommence the contract, but the difference in price between what it was at the time before suspension and what it is now is in the tens of millions. And the difficulty with that is that in this suspension scenario, neither the suspension document or the contract has any clause that effectively says how you would calculate the difference properly, how the parties would agree to calculate the difference between what the price was then and what the price would be after a suspension. So there's no indexation, there's nothing like that. And that's obviously a major problem. So sometimes when the parties are in a rush to, make a change or agree a variation or agree a suspension, they maybe haven't thought about the next step. What happens next once we get over this variation or once we get over the suspension? How do we deal with that? So always think of what the next step is if you're making a change or a modification to a contract. Similarly, always make sure that you have all your terms captured in the form of the contract. I have another example whereby a client had a number of contracts with the counterparty, but they had verbally agreed a discount procedure for early payments. And you can imagine how that went. That wasn't documented. It was a verbal agreement that went contrary to the terms of the contract, and the documentation went contrary to our understanding of it as well. So sometimes there is that difficulty too. If there is a contract in place, but parties agree a verbal change, like that can work against you by the principle of estoppel. So always be mindful of making those changes and make sure they're documented properly. Similarly as well, make sure that in terms of your contractual liability and clauses, that you have a proper right of recovery. Recently advising a client on a matter whereby our client's right of recovery is limited to the counterparty's right of recovery against a third party. So effectively, if our counterparty can't recover against a third party, their liability to us might be zero. So that again are sort of simple things that I think are just overlooked when maybe contracts are being entered into, and then that's when issues then arise and have to be dealt with. So what I would also say is that if you're in correspondence with a counterparty and you have good terms with them, good relations, then all of a sudden they're sending you more letters, they're sending you emails every day, and you start to notice that they're referring more to the contract terms and conditions, and maybe they're, using phrases like obligations and entitlements and rights and remedies. That might be an indication that they're speaking to their lawyers. So always sort of analyze the correspondence that you're dealing with, and if you notice a change in their form or their tone, and particularly, they're maybe using lawyers to correspond with you, and that then can either indicate that they have an issue or they're going to bring a claim or seek some sort of contractual relief. I'd always say just like it's always worthwhile actually just stress testing understanding of projects and how issues are to be dealt with. But I would go back to that scoping point that I had. That was actually a very simple oversight, but caused major difficulties for our client further down the line. And really, I think it would have been a case whereby had the parties maybe sat in the room and really stress test the overall structure of the arrangement, I think that issue might have been dealt with better. And really, my last point is that contracts don't really work in isolation. You're often dealing with people, and emotions can get in the way, and people always want to be right. So even the best legal arguments sometimes don't get you a quick resolution. But also be mindful of that. Even if there's a breach or termination of a contract, that's a cost, not just the cost that's determined under the contract, but a cost to the business in terms of getting a new supplier, but also a cost to the business in terms of management time and resource. So that I think concludes today's webinar, and I'm happy to take any questions that have come up during this time. Thank you very much.
Thanks, James. A lot there to take in and reflect on. We will be circulating the slides probably tomorrow. So, James, just a few questions. I think we've got about 5 minutes left. First one, if a contract term is ambiguous, does the law favour any party to the contract?
Yeah, so there's a legal principle of contract pro forentum, which effectively means that if the drafter, it usually goes contrary to the drafter if there's ambiguity in a term. It goes against the offer. So if a party was effectively if a party had effectively drafted or included a provision that was ambiguous, typically in that ambiguity would be considered to go against them because they should have actually stated what they wanted to say.
Right. Okay. One here. In the future, do you think the use of smart contracts will reduce the number of contractual disputes?
Probably not. I think we appreciate where smart contracts are obviously very interesting. But I just think that disputes just really they effectively come with human nature, and I think that even though smart contracts are trying to maybe dilute that sort of interface, I still think that there's always ambiguity. Like really, contracts are just trying to mitigate risk and narrow uncertainty, but they can never fully exclude it. So I'm more in hope there than expectation, I think, about the disputes piece.
Yeah, okay, thank you. Can correspondence labelled without prejudice be held against a party?
So typically not. So look, without prejudice can be used either in contract negotiation or in disputes or in any form of business or transaction, really. The thing that to be mindful of is that if a court would take a very dim view if one party to a dispute submitted without prejudice correspondence to the court, because the court aren't really intended to see it. It's basically made without prejudice. It's not a fixed position, and there is a difference between what's an open correspondence. If it's not labelled without prejudice, it's probably treated to be an open correspondence, and that can be your position on record. Whereas without prejudice is to try and not be on record and trying to find some sort of room for negotiation. So the difficulty would be if one party effectively submits without prejudice correspondence, either erroneously or to basically show the court that the other side were trying to do something that they didn't approve of. There's always a risk that once you do that, the without prejudice privilege is lifted and waived, and people sometimes can do that. The courts may often take a dim view on that unless there is strong reasons to the contrary. So typically, I would say no, you can't, and probably shouldn't. But that's not to mean it doesn't happen.
Okay, thanks. I have one more question, but folks, we've got about 2 minutes left. So if anybody else has anything, if you just pop your questions into the Q&A. Otherwise, James, the last one. What is the most common type of loss that is disputed between parties following a breach?
I think it'll probably depend on the specific nature of the contract. I have an example at the moment now whereby there's this will relate to other points that made in the webinar. I'm involved in the dispute at the moment where one party was terminated for poor performance, and under the contract, our client's entitled to recover all the loss that came from the breach of contract, or from a termination, I should say. And there's a dispute over what that actually means in terms of the cost applicable. But what is interesting is that in this procedure that we're in, we have to verify and substantiate every single loss that we've incurred. So that means we have to, for every penny we claim, we have to justify. So that's a very onerous exercise. Like, it's a major document management task. That is, I would say, there's a major loss of profit. I think loss of profit's a real key one in terms of what we're to be asked to advise upon. But I think when you're trying to establish loss and there's a dispute over what that loss means, very occasionally you'll have to instruct an expert or another team to effectively help advise you, i.e. accountants, what your loss actually is. And the concern would be that you also have to substantiate your loss. I'm not just saying this is what our loss is we expect it to be. In some instances, you're asked to substantiate it to the very penny. So that could be the receipt of a taxi that one party took to a location, things of that nature. You'd be surprised, and I'm surprised the minutiae we have to go into on this, but it is quite the task. But I think that in terms of one of the major things that we would say is loss of profit, but I think loss of data is going to be a major one. It is a major one, but I think going forward, particularly where we're headed, I think it's going to be one that's majorly contested in terms of the damages.
Okay, James, I don't have any more questions. I think it's fair to say, you mentioned it a couple of times, the devil is in the detail.
Yeah.
So folks, it's 2 o'clock. Hope you all enjoy the rest of the day. The sun's shining here as I look out the window, so hopefully it stays that way at 5 o'clock. Thanks for joining. Thank you.
Thanks, everyone. Thank you.